So we're going to now hear from Gunda Schumann. She's from Germany. She's a lawyer, sociologist, and activist member of Lesbische Aktionszentrum, LAZ Reloaded, author of Legal Opinions addressed to German legislature on bills dealing with gender ideology issues. So thank you so much, Gunda.
There is no gender in Germany, in German legal language. However, instead of gender identity, Geschlechtsidentität, literally called sex identity, is being used, adopted by the German Federal Constitutional Court, I call it FCC, in its decisions on transsexual and intersexual claimants, aiming at change of sex entry in the civil status register since the year 2005. I will talk today on the following topics. What is the legal basis for sex identity in Germany? What is the impact of sex identity upon the constitutional rights of women? How has sex identity found its way into regular German law? Some words on the status of current efforts to introduce a self-ID law in Germany. And finally, conclusions and counter strategies by feminists. So I come to the first question. What is a legal basis for sex identity in Germany? I have to look at the rulings by the German Federal Constitutional Court. The FCC urged the German federal government in 1978 to enact legislation that would allow transsexuals to change their sex entry in the civil status register following a regular procedure. The reason was FCC decided a constitutional claim in favor of a gender reassigned man wishing to change his sex entry in the civil status register based on Article 1 and 2 of the German Constitution. These articles say obligation of the state to protect human dignity and the right to free development of personality. Nothing about sex. In 1980, the Federal Parliament passed a law on transsexuals, laying down the conditions for change of first name, they called it small solution, or a change of sex entry in the civil status register, they called it large solution. The conditions for the large solutions are a court procedure, 2 independent medical and psychological opinions that determine the persistence of the applicant's claimed sex identity, 3 years practicing the opposite sex role, at least 25 years of age, not married, infertility, and gender reassignment surgery. All conditions except court procedure and 2 independent medical psychological opinions that determine the persistence of the applicant's claimed sex identity have been judged to be unconstitutional by FCC so far and are not applied anymore. All conditions except court procedure, the notion of sex identity has been adopted by FCC in 2005. The years before, it was labeled protection of intimate sexual privacy and right to sexual self-determination. In the cases it had to decide trans and intersex persons, sex identity is enjoying a preference as far as entry in civil status register based on biological sex is concerned. Now a couple of words to the actual number of recognized transsexual persons. Between the years 1995 and 2017, approximately 23,000 trans-identified persons have succeeded in changing their sex entry in the civil status register. These are official data. Now I come to the second question. What is the impact of sex identity upon the constitutional rights of women? First, I will have a look between the relationship of women's constitutional rights and protection of trans-identified persons. Equality between women and men and the general prohibition of discrimination based on sex that protects women and recently also intersex persons, but not trans-identified persons, on the one side, and the articles I mentioned, human dignity and free development of personality, on the other side. What does the Constitutional Court say? It says the German Constitution does not determine a binary gender order, even though the constitutional article that addresses men and women, it has been drafted more narrowly because the state has to take measures to achieve the equality between men and women. My comment is the relationship between the Article 3.2, equality between the sexes, and Article 3.3, protection of women and intersex persons on the one side, and the other articles protecting trans-identified persons do not seem to have been reconciled by FCC in this context. That means the compatibility between the different constitutional rights concerning women and trans persons is still an open question in Germany. What does the FCC ruling says on sex entry in civil status register? The FCC says in a ruling on an intersex claimant that sex entry in the civil status register would not be required by the Constitution, which is alarming. Our conservative Federal Minister of the Interior, however, has objected to that statement, which is very rare in Germany. According to the ministry, sex entry is a relevant factor for all legal relations in society and is serving as evidence. Without sex entry, rights of all persons would be impeded. My comment to that is, if sex entry would be erased, there will be no sex-specific statistics anymore. Equality between men and women required by our Constitution could not be achieved by the state. The background of this ruling is that the judge, Susanne Beer, who drafted the ruling on intersex persons in 2017, has been nominated by the Green Party to the Federal Constitutional Court. She's a queer lesbian law professor. Next question. How has sex identity found its way into regular German law? It is an openly practiced technique by trans lobbyists, attach sex identity to more popular reforms. I'm talking here about the federal law on protection against conversion therapy, which was originally intended to prohibit conversion therapy of lesbian and gay people. Unfortunately, now gender identity has been included. The effects of the law, this law, which has recently been enacted by the German Federal Parliament, is paving the way for harmful medical and surgical interventions concerning children, increasingly young girls, who do not conform to sex stereotypes or are diagnosed with gender dysphoria. The content of that is, assuming an interrelationship of LGBT, the law does not just prohibit psychological treatments that intend to change or suppress sexual orientation, which is desirable, but also so-called self-identified sex identity of minors, a protected vulnerable group. Pursuant to the law, members of the medical and psychological professions are not allowed, under threat of legal punishment, to apply treatments analyzing possible reasons and psychological side effects of juvenile patients suffering from gender dysphoria. Instead, their treatment must only be an affirmative one, being the preliminary stage for gender reassignment of children. Even guardians, mostly parents, are to a lesser extent affected by the prohibition of conversion therapy. Harmful medical and surgical interventions for children are not labeled conversion therapies since they are based on the young person's wish. Consequences are doctors and psychologists are getting criminalized for executing their professional duties. Parents' constitutional rights have been severely curtailed. Harmful medical and surgical interventions for children are getting depathologized since they are based on the young person's wish. Why and how young patients should be able to foresee the consequences of these interventions is lacking plausibility. Infertility, strictly prohibited by German civil code, and mutilation of juvenile bodies are being accepted accordingly. Despite the German constitutional right to physical integrity, the law is adopting transgender ideology, psyche trumps body, which may have a fatal, irreversible consequence among unstable minors with so-called rapid onset gender dysphoria, mostly girls. The legal history is the Federal Ministry of Health, a gay man, had intended to prohibit primarily conversion therapy of lesbian and gay youth, as I mentioned. Half a year before submitting the final draft to the cabinet, the trans lobby succeeded convincing the minister or his aides to add sex identity as a protected category to the draft law. It passed the cabinet and the federal parliament without any major opposition. There has not been any public information on doctors, psychotherapists, psychologists, and guardians breaking the law. Probably they may refrain from seriously treating so-called trans-identified kids in advance obedience. What is the status of current efforts to introduce self-ID law in Germany? There's a draft law by the Green Party and Liberal Party of June 2020 on self-determination, the abolition of the law on transsexuals and enactment of law on self-determination, but this bill did not pass the federal parliament since the Greens and the Liberals are part of the opposition. I make it very short. The applicant, according to this draft, may be a minor of 14 years of age that may apply for change of sex entry with a civil status registered by him or herself merely on the basis of his or her innate sex identity. Another change of sex entry would be possible after a lapse of 1 year. My comment, sex entry is a relevant factor for all legal relations in society and is serving as evidence. Without sex entry, rights of all persons, in particular women and girls, would be impeded. The consequences of this bill would be, if sex entry could be changed to each person's will, sex-specific statistics would be distorted. Furthermore, measures against discrimination of women and girls would become impossible. Equal political participation of women through parité laws, quota grants, women's sport, protection against male violence, freedom of speech and assembly would be in danger. Invasion of men into sex-segregated spaces would finally be legitimized. Invasion of men into the intimacy and autonomous spaces of lesbians strips them of their sexual identity, thus preventing empowerment. And equality between men and women required by our Constitution could not be pursued anymore by the state. Genital reassignment surgery, another very bad part of that bill, that minors may undergo genital reassignment surgery upon their will and the consent of parents or the courts. Hormone treatment would be permitted already for minors between 10 and 13 years of age. Why and how young patients should be able to foresee the consequences of these harmful interventions is lacking plausibility, as I mentioned already. In a public hearing of the Federal Committee of the Interior, WHRC Germany and Lutz Reloaded have submitted critical statements. However, none of them was given the chance to participate as experts. My conclusion: sex identity has been legitimized by our Federal Constitutional Court. Second, compatibility between the different constitutional rights concerning women and trans-identified persons is still an open question in Germany. Third, sex identity has started to infiltrate German legislation. 4, if after federal elections next month, the Green Party and the Liberal Party will join the government coalition, self-ID will become a realistic scenario. 5, counter strategies to keep women's sex-based rights. One tiny light at the end of the tunnel, Terre de Femmes, a large women's organization, will ask other large women's organizations in Germany whether they would cooperate in requesting the German federal government to check so-called gender mainstreaming effects. That means the impact upon women and girls of future laws involving self-ID. If that does not help, feminist politicians would have to file a suit against a future self-ID law with the FCC, since women's constitutional rights must not stand back behind constitutional rights of trans-identified men. If there are none who have the guts challenging sexist laws, women affected by enforcement of the law on prohibition against conversion therapy or future laws on self-ID or on hate crimes against LGBTIQ would have to file a constitutional claim with the FCC.